Hello, everybody, and good evening, and welcome to another live medical legal CME session. And tonight, let me make the slide a bit bigger here. We are going to listen to a talk on titled "Challenges Doctors Face in the Light of the Changing Legal Landscape." And speaker is Mr. Sridhar Sundaram, who is an advocate and solicitor with many years of experience in Asman Davidson and Company. Okay, so this will be a streamed, recorded talk. So you bear with us, and we will be able to show that after some housekeeping slides, just to tell you how this thing works. Okay. Now, the talk will entitle you to one CPD point, and there are a couple of ways for the doctors to claim CPD points. Now, during the live stream, at the end of the session, we will display a QR code which you can scan with the MMA app. Now, this is only for medical doctors who are using the MMA app. Okay, when you scan with the QR code which is displayed, you will get 1 point automatically. However, do note that the QR code is valid only for about 1 hour. So about later on tonight, the code will no longer be valid. However, if you're watching this stream after the live is over, you can still claim CBD points by logging into the CME module in DOPS. Okay, the link is in the video page uh, in the docs.my, and you click on the medical legal part section of the menu, and you will see the 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 live stream the live stream page, and below it, below the video, you see the link to the CME module. I'll elaborate more later. You can ask questions if you're not sure how to do it. Okay. Um, for the dentist, this time you can also claim CBD points. You need to register that you have viewed, and the link is also in the Medical Legal CME page of DOBS. Visit the page, go to dobbs.my, and then in the menu, click on the Medical Legal CME, and there's a link to register for CDB points for the dentist. Okay, and that is handled by the private dental association. Right. Now, if you have any questions for Mr. Sridhar, you can use either the YouTube live chat, okay, but the questions will only be answered at the end of the talk. And if you are viewing this in the YouTube app, it's quite easy to locate the live chat. However, if you are viewing this in docs.my medical legal CME page, you can't see the YouTube chat, but you can switch to the YouTube app by clicking on the title at the top of the video screen, and they'll take you to direct view in YouTube, and you can see the chat. Okay. Now, we'll also allow you to post questions on Slido. And if you're viewing this on your computer, you can take your phone and use your normal QR code scanner, not the MMA one, just the QR code scanner, or else visit slido.com and enter 11888048, and you can ask questions there. So we'll look out for questions on YouTube live chat as well as the Slido. All right. Before we start, I'll just make a little request for you all to subscribe to our channel so that you'll be notified of any upcoming live stream and any of our medical content which we post quite regularly in this channel. Okay, just a little humble request. Okay, and I'll display the QR code on this web page only on this slide after the talk is over. All right, so we are waiting for a few more people to come on board. And in the meantime, we'll just have a little word from Dr. Shield. Okay, just a little word from the organizers of the talk. And here we go.
We're Dr. Shield, and we do insurance differently than most companies. Things like simplifying details so it's easy to understand what makes us Malaysia's most innovative indemnity provider. As a Dr. Shield client, you'll enjoy comprehensive coverage with fewer exclusions. With some insurers, you'll only find out what's not covered when you make a claim. Our policy details are online and easy for everyone to understand. Competitive premiums that don't keep increasing. Many insurers increase their premiums across the board to compensate for losses. Dr. Shield limits the number of doctors insured from high-risk categories, so our premiums start fair and stay fair. Prompt dispute resolutions. We're pro-mediation because settlement and negotiation, instead of endless litigation, is better for everyone. Career and reputation protection. Typically, litigation can drain a doctor financially and emotionally. We limit the damage by both, so our clients emerge good names intact. And peace of mind, because a happy doctor is a good doctor. Our different approach to creating policies means we put you first, before us, so you can enjoy your career and sleep like a baby, even if you've just delivered one. Dr. Shield, insurance with a difference.
Okay, thank you, Dr. Shield, for helping us in organizing the series for you to learn about medical legal matters. So, without taking too much time, I'm going to start the stream of the Mr. Sridhar's recording, and I think you can see online on the page right now. Uh, and I'm going to start the stream now.
Good evening, doctors, and thank you for taking the time to tune in. My name is Sridhar. I've been a litigator for almost 3 decades in various areas of law, including medical negligence, and currently practicing at Usman Davidson & Co. Now, having a number of doctors in the family brings this subject much closer to my heart. And I hope that by giving this talk, I can help doctors be aware of the current standards demanded of them by the courts so they can safely navigate closer to the standards demanded by them and avoid the legal minefield that modern practice has unfortunately devolved to. I'll be happy to take any questions at the end of the session. If you have any further queries or even legal advice, I'll be pleased to hear from you. You can WhatsApp me on 017-888-4759. Now, heaven forbid that any claim for negligence be made against you. But should that happen, these are the hoops that you will have to jump through. The claimant will usually avail themselves of the grievance procedure under Section 36 of the Private Healthcare and Services Act 1998 and seek an explanation or clarification of what happened and a possible solution. At this point, you should inform your insurer or at any earlier instance where you were aware of any circumstances giving rise to a claim. Now, failing a resolution at this point, a claimant engage a lawyer who will write to the physician and request a medical report detailing how the incident giving rise to the possible claim came about. The lawyer will also write to the hospital requesting for a complete set of documents, i.e. the medical records. Now, if the hospital does not give the medical records, an order for discovery can be made, which will just complicate matters and add costs. So it is always a good idea to accede to this request. Now, after that, medical experts in the appropriate field will be usually engaged by the respective lawyers to render a written opinion on whether, in their opinion, there was any negligence involved. Now, depending on the expert's written opinion, a letter of demand requesting for general and special damages, and maybe even aggravated damages, and we'll get to that later, may be issued against the physician or the hospital concerned. Now, if this matter is not resolved at this juncture, a suit will be filed into court. By now, your insurer would have appointed a lawyer to represent you, and the lawyer would have authority to accept services of process. So you would be cut out from having to deal with anything else. You would only have to deal with your lawyer. Now, your lawyer will first have to file a memorandum of appearance. It's basically a notice to court to say that you're legally represented, so all parties are aware that they will have to deal with your lawyer and not with you directly. It also makes it impossible for anyone to take judgment in default or anything like that. Now, the next thing that follows is very, very important. Your lawyer will contact you and request for your help in drawing up your statement of defense. Now, I cannot emphasize how important it is for you to fully cooperate with your lawyer. The statement of defense encapsulates your entire case. If any fact is left out, it's going to be very difficult to introduce it later. So, for example, if the doctor has an alternative explanation as to the injury suffered by the plaintiff, then this is the time to bring it up. For instance, in the case of an ONG case, if the child suffers from shoulder dystocia during delivery, and an alternative explanation such as maternal propulsion is going to be offered up, then now is the time to bring it up. So make sure that you cover all angles with your doctor, with your lawyer at the time that the statement of defense is being prepared. Now, let's see, what else do we have here? Right. Now, depending on the medical expert's opinion, your insurer may decide to either settle this matter out of court or go to trial. The good thing is you still can settle this matter out of court because you have court-assisted mediation to try and get parties to a meeting of minds, as it were. And the mediation court is not going to be the same as a trial court. So you can be perfectly candid with the trial, with the mediation court, and hope that this brings an end to litigation. If this fails, then yes, then the real wheels of justice are going to start grinding. This will take maybe 6 to 8 months before it comes to completion. So what happens is the lawyers acting for the parties will have to attend a series of case managements over many months, wherein the court will give instructions on the preparing, filing, and exchange of list of issues to be tried, agreed facts, list of witnesses, case summaries, bundles of documents, and expert reports. Now, barring any interlocutory applications, such as amendments to pleadings or applications to strike out, the matter will then be fixed for trial. The number of days will depend on the complexity of the matter and the number of witnesses and experts who are going to be called. There will be pre-trial preparations to prepare the physician and other witnesses for trial. The complainant's witnesses will take the stand first. This is where the complainant's witnesses will give their testimony in what is called examination in chief, typically by way of a Q&A statement. This is then followed by cross-examination by your lawyers, and then re-examination by the plaintiff's lawyers. And the same process then takes place with you. And if the hospital's witnesses are going to give evidence, then the same thing. So it's just a repetition. Now, once all the testimonies have been given, the court will give a date for written submissions to be filed and exchanged. Following which there will be a date given for oral submissions to be made, after which another date will be set for the delivery of the decision. All decisions are appealable. The role of the experts cannot be downplayed. It would be good if you could recommend or suggest an expert to your lawyer whom you know is competent in your particular field. But of course, the expert has to be seen as independent and unbiased. So you can't have an expert who is beholden to you or is too closely attached to you. Nowadays, a phenomenon called, not phenomenon, it's a procedure called hot tubbing, where two experts will sit down and discuss the case just with the judge, with the lawyers in the background. It's gaining traction, and it's something that you might want to consider speaking to your lawyer about. Now, in order for you to avoid all of this and not get into litigation in the first place, what you need to do is be very aware of the onerous, and it is onerous, I'm afraid, duty of care that you owe your patients. If you are very well aware of this duty of care, then there's a good chance that you can avoid litigation altogether. Now, in law, a doctor's responsibility or duty of care is broken into three limbs: diagnosis, advice, and treatment. Now, advice covers what we call advise, info, warning. So the risks and benefits of a particular treatment have to be conveyed to the patient, plaintiff. And now that also includes taking of history. If you think that the patient is not giving you good history, is unable to do so, then you might want to reach out to the patient's previous physicians to confirm the patient's medical history. If, on the other hand, you think that the patient is giving you very good history, then you might be excused. But to play safe, when you're taking history, not a bad idea to reach out to the previous physician to make sure that you get the history correct. Now, many doctors believe that as long as the diagnosis and treatment of a patient is not flawed and meets the approval of theirs as experts in a court of law, they cannot be held liable for negligence. Sadly, this is not true. Now, in the case of Chester against Ashfar, 2004, which involved a failure to warn a patient who underwent surgery of the 1 to 2% risk of cauda equina syndrome. The operation was not carried out negligently, but the claimant's case was that had she been warned of that 1 to 2%, she would have delayed the operation to reconsider and take a second opinion. Now, giving judgment in her favor, Lord Stein said, in modern law, medical paternalism no longer rules, and a patient has a prima facie right to be informed by a surgeon of a small but well-established risk of serious injury as a result of surgery. So, for diagnosis and treatment, the courts must accept the views of a responsible body of men, skilled in a particular discipline, and the courts cannot resolve differences of expert opinion on its own. That means that as long as you have a credible expert that justifies and supports the treatment, management, and diagnosis that you made, then despite the fact that there are other experts that don't agree with your expert, you will still be exonerated. The catch is that your expert's testimony must be able to withstand logical analysis. So insofar as treatment and diagnosis is concerned, the court cannot substitute its views in place of the expert's views, because the court is not qualified to do so. The court is obliged to take into consideration the expert's views unless that expert's view is incapable of withstanding logical analysis. Now, unfortunately, the development in law is that that no longer holds true for advice, info, and warning. Right? So now the law has been redefined in 2015 so that, as I said just now, treatment and diagnosis still within the realm of the expert. Advice, info, warning, no longer has the court got to listen to the experts. The court can substitute its own views. So in 2015, the Supreme Court in the UK on the case of Montgomery against Lancashire Health Board. Now, Nadine Montgomery, a molecular biologist with type 1 diabetes and a relatively short stature, gave birth to a son, Sam, by vaginal delivery in 1999. Her labor was complicated by shoulder dystocia, which resulted in a 12-minute period of acute hypoxia, and Sam being born with cerebral palsy and traction-related Erb's palsy. Montgomery sued for negligence, arguing that she would have requested a C-section had her obstetrician informed her of her personal 9 to 10% predicted risk of shoulder dystocia based on known factors. The Supreme Court judges ruled in her favor and declared that the doctor should ensure patients are aware of any risks material to them and also any reasonable treatment alternatives. The material risk of whether the materiality of a risk was defined as whether a reasonable person in the patient's position would likely to attach significance to the risk, or the doctor is or should reasonably be aware that the particular patient would be likely to attach significance to it. So clearly, this is a totally subjective viewpoint. The court will literally sit in your patient's chair. It will wear your patient's shoes, and it will decide whether the advice that you gave it was reasonable or not. So it's totally patient-centric, right? So now in the post-Montgomery area, the belief that there is a percentage threshold of improbability below which a risk need not be disclosed is unfortunately outdated. Consent discussions must now be tailored to the physical, emotional, and even spiritual needs of the individual patient to identify which risks could hold significance and premised on the following principles. The principles are: the right to accept or refuse treatment is a basic human right. The doctor has a duty to inform the patient of the material risks. The onus is not on the patient to ask. The threshold is lower for those who lack knowledge or express anxiety or only in more general concerns. What this means is that if the doctor is of the opinion that this particular patient is for perhaps psychological reasons unable to comprehend or appreciate advice, info, and warning, then perhaps the doctor can be excused. Then, of course, there's also the question of whether the family members could have been consulted. Going on. So the doctor has a duty to provide sufficient information for the patient to make an autonomous decision. So the importance here is that the patient must be able to make an autonomous decision. Frequently occurring but less serious outcomes may be as important to the patient as a serious outcome of which the risks are small. The doctor has a responsibility to explain which is the medically preferred option and why. The doctor must not assume that the patient is medically uninformed or incapable of understanding medical matters. Whether a risk is material is to be judged by what a reasonably prudent patient in the situation of the patient would regard as a significant risk. A material risk is not a matter of clinical judgment. The patient is entitled to take into account non-medical matters, such as their circumstances, objectives, and even values. The doctor must respect the patient's decision, even if it is not the medically preferred one. So what Montgomery made clear is that the duty to discuss risk goes beyond the duty to discuss known risks. That is to say, there may be factors of importance to the patient which, if discussed, would affect their decision-making. It is clear that the process is one that involves dialogue. So unless all information is given to the patient, the healthcare professional potentially deprives the patient of key information to make a properly informed decision. For that decision, Lord Kerr specifically noted, whether a risk is material cannot be reduced to percentages. Only a patient can decide what is an acceptable risk. It is noted that the requirement to provide adequate and complete information extends throughout care. In the case of Gallardo against Imperial College Healthcare, the court had to consider whether there was an obligation to provide full and complete information after the conclusion of the treatment. The claimant had been in intensive care and was therefore too unwell to discuss matters preoperatively. It was found that further information should have been provided. The claimant was not adequately advised postoperatively about his malignant tumor, such that his subsequent treatment under other clinicians was suboptimal. So, to just try and sum it up for you, you have a complaint. Now, the first thing is diagnosis. Now, if that diagnosis is attacked and goes to court, then under the original Bolam test, as long as your practice is supported by a reasonable body of medical opinion, which is internally consistent and logical, then you cannot be held to be negligent, because diagnosis is within the realms of the expert. The same thing applies to treatment. Even if your treatment is attacked, as long as you have an expert who can say that your treatment was proper and his opinion can withstand logical analysis, then you're off the hook. Now, insofar as advice is concerned, that's where it gets a little bit murky. So, first of all, was that advice given to the patient? Of course, if that advice was given to the patient, then you're off the hook. Now, the important thing is here, how do you prove that that advice was given to the patient? Now, this is where note-taking comes in. A lot of doctors may have given the advice to the patient, but neglected to record it in their notes. And if it wasn't recorded, then it wasn't done. So please make sure that you record all of this in your notes. So if it goes to trial, then, you'll be exonerated. Now, if the information was not given, then it goes back to the Boland test. Is that information, would that information have been within the knowledge of the reasonable doctor? Now, if experts say, well, that's not something that reasonably could have been within the knowledge of the doctor, then again, you're off the hook. Now, if the experts say you ought to have known that, you ought to have had knowledge of that information, then obviously you should have given it to the patient. Now, the only thing that can save you there would be if you can argue that the patient was in a position that he or she was psychologically impaired, or giving that information would have just caused unnecessary anxiety, and therefore you, as a doctor, you withheld that information. But that's a dicey thing there, but it might get you off as well. So that, in a nutshell, it covers those grounds. Now, what is the approach that you need to take in order to stay on the right side of the law? Now, thousands of doctors engage in complex discussion with their patients to identify which, if any, treatment to pursue. Central to each of these discussions is the notion of informed consent, whereby the doctor discloses material information about the treatment or procedures and facilitates understanding so the patient can decide which option they prefer. Now, consent discussion must navigate the interface between beneficence, non-maleficence, and patient autonomy. Now, this is a considerable challenge in a time-pressured healthcare setting. Facilitating good understanding of the indication and nature of treatment can improve patient satisfaction and preoperative anxiety levels. In contrast, failing to engage patients in the consent discussion can lead to a loss of trust and heightens the risk of litigation in the event of post-operative complications. So, you have to give information in a way that allows the patient to weigh up the potential benefits, risks, and burdens of the various options, as well as any non-clinical issues are relevant to them. The patient decides whether to accept any of the options, and if so, which one. This means you also have to give the patient advice on what if you don't take the patient doesn't take any treatment at all. What happens to the patient if there is no treatment? You have to give the patient options of conservative treatment, not just the field that if you're a surgeon, for instance, you might prefer to do surgery, but you also have to give the patient the alternative of conservative treatment. I mean, that may include, I don't know, acupuncture or just medication, but you have to cover all grounds. So in relation to risks, remember, you have to tell the patient if the treatment might result in a serious adverse outcome, even if the risk is very small. So if you're talking about mortality, fatality, even if there's a very small risk of fatality, you have to tell the patient about it. On the other hand, you also need to tell the patient about less serious complications, a rash, for instance, if they occur frequently. I'm just going to briefly touch on this. I don't think we have this in Malaysia, but this is something that is being noted overseas. An alternative approach could be to develop a repository of patient decision aids, called PDAs, in the form of evidence-based interactive websites with embedded multimedia, example, graphics or videos. So this is something that you might want to think about, and you can get a wealth of information online, and it allows patients to interact online and then highlight those areas of concerns and only take up your time in discussing those areas of concerns. Now, If the worst happens, how best to mitigate the fallout? Now, these are my observations from my personal experience in dealing with cases involving medical negligence. Engage the complainant. Don't avoid or summarily dismiss complaints, even if you think they are trivial. Adopting a defensive or evasive stand will almost always escalate the situation. But don't admit fault or offer compensation without legal advice. That can be taken as admission of liability or guilt. Now, just taking the time to listen to the patient's grievances and offering some explanation or advice or assurances, as well as being sympathetic, goes a very long way to diffuse a potentially explosive situation. Now, even if you have been negligent, you are less likely to be sued, or even if you are sued, you're more likely to be able to amicably settle it out of court if you're perceived to be an approachable, understanding doctor and are genuinely concerned about the patient's well-being. Those few extra minutes you spent entertaining a complaint, no matter how trivial or how unjustified it may be, may ultimately save you countless sleepless nights and months of expensive litigation, not to mention loss of profits by having to close your clinic to attend briefings, mediations, and trials, not to mention loss of reputation. If a claim is intimated, notify your insurer or broker without delay. Remember, once a suit has been filed, even if it is withdrawn, settled out of court, or successfully defended against, it will nevertheless result in a huge increase in your insurance premiums. So, practical steps to minimize the risk of litigation. Document everything. Use electronic, audio, or video recording equipment if you can. Don't rely on standard printed consent forms. The use of procedure-specific consent forms can reduce variability in documentation of complications, avoid omissions of relevant operative risks, improve patient recall, and would be expected to reduce documentation time. Don't leave the task of consent taking, advice, information, or warning to nurses or juniors. If possible, have an attending nurse or junior to sign off as a witness to consent forms. Now, if you've been negligent, that negligence could have caused an injury to the patient. And if that is proven in court or liability is admitted, then you will have to think about damages. Now, there are three heads of damages. The first head is special damages. That is damages that can be quantified. Cost of treatment, travel costs, future treatment costs, modification to homes or cars or anything that you can put a price tag on, special damages. Then you have general damages. Now, general damages are things that you can't put a price on and will have to be assessed by court. Typically, this would be pain and suffering. Now, normally, it's limited to that. Special damages and general damages, and this is typically covered by your insurance policy. So up to the limit of your policy, general damages and special damages will be covered. Now, unfortunately, in a rather disturbing development in Malaysian law, a third head of damages has been raising its ugly head, and that's called aggravated damages. Now, the first thing to note about aggravated damages is it can be avoided. Now, insofar as special and damages, it arises from negligence. Obviously, you didn't intend to be negligent. It was an omission, it was inadvertence, it was an oversight. You didn't intend for it to happen, but it happened anyway. But with aggravated damages, you can avoid it if you are careful, because aggravated damages is your behavior where you have added insult to injury. Having already been held to be negligent, you then acted in a manner which added insult to that injury. So you can easily avoid it just by being careful. Now, the best way I can show you that is to take you through some case law. It's going to be a bit boring. I'll try and make it as brief as possible, but these are real life instances. You can see the mistakes made by other physicians, and hopefully you can avoid them. Now, the locus classicus, if you like, of aggravated damages is the case of Dr. H and another against Magat Noisha in 2018. Now, the patient had a giant retinal tear with detachment in his right eye, and he consulted Dr. H at his private clinic. Dr. H advised the patient to undergo a retinal detachment operation immediately and performed the operation. That was the first operation on the plaintiff. The plaintiff later complained of continuous pain and strong pressure on his eye. Upon a physical and visual inspection, Dr. H informed the plaintiff that the retina in his right eye had folded outward and that a second operation had to be carried out to repair it due to the urgency of the situation. The plaintiff requested for a scan to be confirmed the findings, but was told by Dr. H that it was not necessary. The plaintiff initially requested for the anesthetic services of his previous anesthetist, but Dr. H assured him that the anesthetist on duty, Dr. N, was equally competent. The second operation was carried out, and when the plaintiff regained consciousness, he was informed that some problems had occurred during the second operation. Apparently, the plaintiff had bucked while Dr. H was strengthening the retina using a laser. As a result, the plaintiff suffered suprachoroidal hemorrhage and extensive hemorrhage with profuse bleeding in his right eye. Subsequently, the plaintiff experienced severe pain, continuous bleeding, and total loss of vision in his right eye. In a medical report, Dr. H confirmed that the plaintiff's right eye was permanently blind due to a retinal detachment. The plaintiff filed a civil suit against Dr. H, Dr. N, and the hospital, alleging that the injuries and the loss of vision in his right eye were concerned by the negligence of all three defendants. Now, the High Court allowed the plaintiff's claim and found that Dr. H and Dr. N were negligent in failing to warn the plaintiff of the risks of bucking and blindness, and in the care and management of the plaintiff. The hospital also found to be liable vicariously. Now, accordingly, and this is what accordingly, the plaintiff was awarded $200,000 as general damages. This is normal for loss of vision, depending on the age of the patient. $200,000 is the normal damages that would be awarded for pain and suffering. But what shocked the medical and legal fraternity was that a sum of $1 million was awarded for aggravated costs, because the patient had not been warned that after the event that in fact he was already blind, and he was given the false impression that further procedures could be conducted, and therefore, because he wasn't told the truth about his blindness, this was held to be an aggravating factor. And in most policies, and you need to check your insurance policy here, aggravated damages are not covered. So that will have to come out of your own pocket. So that's something that you really need to think about. Now, following that case, we've had some other disturbing cases, and they are the case of Pew Pew Ma against Dr. L. Now here, a Rohingya refugee was admitted to labor ward at Klang Hospital. Slow labor hastened by administering oxytocin, and a baby boy weighing 3.25 kilograms was born. A episiotomy incision was made to facilitate delivery and sutured post-delivery. Following resuturing, pockets were discovered in the anus by the third defendant nurse. The fourth defendant doctor examined the patient and found third or fourth degree tears, and referred to the anesthetist fifth defendant, who found perineal injuries of a serious nature. The sixth defendant surgeon found perineal area contaminated, inflamed, and perineal tissues friable. An open repair of the perineal injuries and a colostomy were performed, so the plaintiff regained consciousness, fine colostomy opening, and was discharged. But a few days later, was found to have perineal injuries painful and discharge of pus. The plaintiff sought treatment at another clinic, who removed the sutures, cleaned the wounds, and gave antibiotics. The plaintiff followed up at the hospital, and later a successful reversal surgery was performed. But the plaintiff complained to be suffering from sequelae, and likely to do so for the rest of her life. Now here, negligence was found to have taken place, and the aggravated damages were held to be, the plaintiff was awarded cost of treatment, traveling expenses, and for pain and suffering for 7 months and permanent scars, $250,000, and $75,000 for aggravated damages. The conduct that led to the aggravated damages was that one of the witnesses lied under oath. He said that he did not undertake delivery and that the lighting in the labor ward was insufficient, and he was also found to be non-compliant with SOP. So giving testimony that is not entirely true can attract aggravated damages. Actually, that can also attract some time in jail if you're found to be lying under oath. Now, not complying with SOP, I disagree. Not complying with SOP should be under negligence, but this court found that failure to adhere to SOP was also aggravating the situation, and that led to aggravated damages. In this particular court, violation of the patient's autonomy when failing to inform plaintiff of the choices of treatment was also held to be contributing to aggravated damages. I disagree with this, but this is the troubling direction in which courts seem to be taking. There seems to be some gray area between what is negligence and aggravating damages. And quite surprisingly, in this particular case, the judge found issue with the expert. The judge found that the expert's conduct during trial was not to the judge's liking. And again, this was held to be contributing to aggravated damages. The defendants had also filed an interlocutory application, which was called Application for Security for Costs, midway. And again, the judge held that this was an attempt to stifle the plaintiff's litigation, and that also contributed to aggravated damages. Personally, I disagree that that's the case, but these are certain developments that we have to be aware of. Then there's also the case of Nur Shafina binti Sa'ari against Kerajaan Malaysia in 2019. Here, non-disclosure of medical records, and the internal inquiry report, which concluded that the defendant's negligence was caused by the injury, was held to amount to aggravating factors leading to aggravated damages. So this is why it's very important to make sure that medical records are made available at the first instance. And the fact that the internal inquiry report had held that the doctors were negligent or the hospital was negligent, and yet a defense was filed denying liability, that was also held to be contributing to aggravating circumstances and resulting in aggravated damages. And here, aggravated damages came up to a hefty $200,000. Then we have the case of, just give me a second, Datuk Stanley Isaacs against the government of Malaysia in 2018. Now, the late Tok Puan Dr. Suzanne Thomas, the deceased, had served the government of Malaysia in the medical and health services for 36 years. The deceased sought treatment at Tropicana Medical Center, TMC, for swelling and severe pain in her right ankle. The consultant orthopedic surgeon at TMC diagnosed the deceased's condition as septic arthritis of her right ankle. The deceased then made the fateful decision of having her condition treated at KLGH, since she was a patient of KLH and all her medical records were there. In fact, the deceased had been the head of the outpatient department at KLH at one point in time in her career. Due to mismanagement, according to the court, the deceased passed away at KLH. Now, I'm not going to trawl through a lot of information, but I'm going to go straight to the factors that the court held were aggravating factors and gave rise to aggravated damages. Failure to follow up on the blood investigations ordered by KLH. The prescribing of contraindicated drug, tramadol, against patients' own specific instructions. The late and false entry in the medical records saying that the deceased and her family had agreed to try tramadol. Failure to observe the deceased's condition and to act on it. The inaccurate entries in the medical records suggesting that the deceased was well. The squeezed in and erroneous late entries into the medical records, failure to have the doctors treat her when she was slowly slipping away in the midst of retching and severe distress with headache, the unfounded allegation that another doctor who was related to her had interfered with the deceased's treatment, the cruel and insulting remarks made by the second defendant that he would have done the same all over again after having known that his diagnosis was proven reckless and fatal, the misuse of in-house experts to try and defeat the plaintiff's claim, and the misuse of the Bolam test. All of these things were held by the learned judge to amount to aggravating factors. Now, I think one of the most damning features was the insulting remark by the second defendant, "I will do the same all over again." And the learned judge actually looks at the notes of proceedings and highlights what was said by the plaintiff witness. And I'm only saying this so that it is, because I think it is important for doctors to realize the things that they say and do, even after a complaint is made, will reflect upon them. And if you say and do the wrong things, then this will reflect very badly on you and can attract compensation by way of aggravated damages, which could have easily been avoided if you had just taken care about what you said. So here, according to the plaintiff witness, both he and the medical officer who saw her at the A&E were adamant that the diagnosis was wrong, i.e. the diagnosis by the earlier hospital. He could not explain why he did not check on the results of the blood test taken by Suzanne at the A&E department before her admission. He defiantly rejected my argument that he had blood results from the laboratory of another accredited hospital, which is sufficient for him to do any emergency procedure to prevent deterioration in her health. He was egoistic to maintain that he knew what he was doing with my wife. He refused to answer why there was no doctor present to monitor her condition, having regard that he had ordered to give her pain medication called tramadol, which Suzanne had specifically informed the medical officer that she was highly intolerant to and that she was not to be given that medication. He had no answer when it was said to him that she started vomiting after tramadol was administered to her. My son-in-law, Dr. A, questioned him many times over about his failure to follow or adopt basic medical procedures with the condition of a patient like Suzanne, but he was at all times defending himself to the point where he lost his temper, and Dr. F had to calm him down and manage the rest of the discussion. When asked, did Dr. S and the medical officer express sympathy and empathy? No, they did not. On the contrary, Dr. S said to all the family members present at the conference, this would have been the grievance procedure, that if given a chance, he would do it all over. He would do everything the same way. He was so defiant even after it was proven that the diagnosis of septic arthritis given by Tropical Medical Center was correct. The independent expert report of Professor Y.K. Chan had established that the cause of Suzanne's death came from the mismanagement and professional misconduct of Dr. S and his team. When asked, how did you and your family members feel after hearing Dr. S's explanation, testimony was tendered in court to the effect that I felt that Dr. S' statement was an insult to the terrible condition that he left my wife in. The statement by him displayed arrogance in him. I felt that Dr. S knew that he was wrong in the way he handled Suzanne's case, but because of his huge ego, he refused to admit. I was devastated by Mr. S's behavior and his insistence that he was not at fault for the condition in which my wife had fallen into, namely a comatose state after suffering a massive stroke, shortly after which she died. This is the same feeling that of my son and my daughter who were present at the conference. And this is what the court had to say. The court takes a most serious view of the second defendant's words and conduct, which are disturbing, appalling, and an insult to his profession and to the plaintiff and his family. It must have been painfully cruel for the plaintiff and his family members who attended the meeting to hear such utterance from a professional medical doctor. There can be no clearer illustration of insulting conduct which justifies an award for aggravated damages. So I hope you take away from this the message that this could have been easily avoided if only there had been some empathy and sympathy shown to the patient's husband and immediate family. One or two other cases that I may want to look at. Okay, there's this case of Ahmad Takif Hamza bin Ahmad Huzairi. Here, a patient had been taken to a hospital because he had fever and swelling in the neck, and then due to delays in scans and so on and so forth, the growth in the plaintiff's neck was found to have blocked off the airway, deprived his brain of oxygen, and he suffered of hypoxic ischemic encephalopathy, causing him irreversible brain damage. So here, negligence was held to, the doctor was found to have breached his duty of care. And again, I'm going to repeat this so that you understand what are the kind of things that you can do that will be held to be a breach of duty of your obligations to your plaintiff, to your patient. Now here, the second defendant had breached his duty of care to the plaintiff by failing to advise and or issue a referral letter to the plaintiff's parents to take the plaintiff to a general hospital soonest, if not immediately from the date of the plaintiff's second visit to his clinic. There was nothing in his medical report to show that he had explained the seriousness of the plaintiff's condition to his parents, or the fact that he had advised the plaintiff to be taken to GH promptly. So again, it comes back to note-taking. You may have well said it, but if you didn't put it in your notes and you didn't issue a letter of referral, then it's going to come back to bite you. There is also no record that the plaintiff's parents had refused to take the boy to GH. So if you've given advice and the patient's parents or the patient refuses to take the advice, it would be prudent to note it in your medical records. It goes on to say the medical report also did not record the size of the neck swelling, despite his noting on the plaintiff's second visit that the size has increased. The defendant had failed to demonstrate any urgency to subject the plaintiff to further examination. This resulted in the aggravation of the plaintiff's condition, causing him to suffer permanent disability. Despite the seriousness of the plaintiff's condition, as admitted by the 3rd to the 12th defendants, the plaintiff was only attended to by a specialist almost 14 hours after he first arrived at the A&E department at GH. So again, delay, I am sure you're well aware of this, can amount to negligence and also aggravating factors. Neither the 4th nor the 6th defendant who attended to the plaintiff referred the matter to a specialist on call with promptitude. So again, how fast if you feel that you can't handle this matter and you ought to have referred it to a specialist, waste no time in doing it and make sure that it's recorded. The plaintiff was at high risk and should have been referred to a specialist without delay. It was in evidence that the ultrasound and X-ray examinations carried out by the defendants were unnecessary and that an early CT scan should have been done. Although it was planned to be done as early as 9:45 a.m., it is evident from the hospital's progress report that the CT scan was only done about 2 hours after the patient had collapsed. It is evident that the defendants had breached their duty of care by failing to act with urgency to ensure the plaintiff's airway was not blocked. And this is what ultimately caused permanent brain damage to the plaintiff. And here, because the hospital did not give medical records until it was forced to do so, aggravated damages of $100,000 for suppression of medical records and the filing of a defense denying liability despite overwhelming evidence of negligence. So $350,000 for pain and suffering and loss of amenities of life, and $100,000 for suppressing the medical records and filing a defense. These could have been avoided. So I hope you take away from this talk the need to avoid behavior, the need to avoid filing defenses, denying liability if in fact you have an internal report that says you're liable. Just try and settle the matter as quickly as possible and you'll save yourself a lot of angst and costs. This, of course, does not mean that in a 50-50 case where you have a good chance of denying liability, that you shouldn't deny liability. It all comes down to your expert's report. If your expert's report totally exonerates you, then you're on good grounds to file a defense and defend your action. This, of course, does not mean that you cannot settle at mediation or come to some sort of compromise at any point in time. But if your own expert's report does not support you, if an internal report points the finger at you, then you really need to think carefully about whether or not you want to deny liability, because then it will attract an award for aggravated damages. That's about all I have to say to you this evening. I will see you soon, and I hope to hear any questions that you might have to put to me, and I'll do my best to answer it. Thank you very much, and good night.
Thank you very much, Mr. Sridhar. And I will just point to the Slido link. You can scan and use the code 11888048 if you wish to post any questions on the Slido. But we got a whole bunch of questions on the YouTube live chat. I'm trying to invite Mr. Sridhar in to the studio. Okay. Okay, Sridhar, are you there? I can't see your camera, but your microphone is on. Okay. Anyway, there are a lot of questions and not much time left because we've exceeded about now it's almost an hour, but never mind, we'll exceed. So I hope the broadcast was clear enough for you. And what I'll do, I'll just highlight the questions on the screen. Okay.
Can you hear me?
Yes, I can see you, Sridhar, but can't see your webcam. Can you turn on your camera? Yeah.
Hang on. Right, I seem to have can't work out how to switch on the camera.
Yeah, okay, never mind. Try again. Sorry. I'll just highlight the question on the screen like that, like so. Yeah.
Can you see me now?
We can hear you, but
Okay,
can't
maybe
see your
that's not a
camera.
bad idea.
Okay, can you see the question on the screen? In
Yeah.
your opinion, what are the most significant legal challenges that doctors currently face? From Dr. John Doe.
Right. Good evening, Dr. John Doe. What are the most significant legal challenges that doctors currently face? Well, one is this specter of aggravated damages and more recently punitive damages, which seem to be running away from us. Unfortunately, other than maintaining a cool head and a sympathetic attitude towards your patients, there's little else you can do. Hopefully you have good legal counsel to try and put the brakes on this runaway horse. That's about it, really. The rest of it you already know, treatment, diagnosis, etc. Keep note taking to the best that you can. So moving on,
He continues. How can professionals effectively navigate these challenges while delivering high quality care?
Well, I think that question has already been answered. Well, one thing that can make it easier for you, and I've said this before, is when you're giving advice, info, and warning, when you're explaining your treatment plan, try and have it recorded audio visually. And of course, you need to tell your patient that you're doing it. And that can save you a lot of trouble later on, because you have clear evidence that you had warned the patient about all the negative things. You had told the patient about the benefits, and you were clear about all the different modes of treatment. I can't think of anything else really.
We'll quickly move. It's a question on telemedicine and digital health. What legal considerations should doctors keep in mind to ensure compliance and protect patient privacy and data security?
Ouch. Okay, I don't really have an answer to this one. I'm not really clear about the question. If you're talking about the PDPA, that's a whole different topic. I'm afraid that we have to research before I'd be able to give you an answer to that. Terribly sorry.
Maybe
Maybe you
sounds
can.
like a whole talk by itself to talk about that.
Yes, yes. You know, I would be happy if somebody could send me a WhatsApp, and that would, I'll be able to sort of get back to you. First of all, trying to get more information about the question, and then I'll be able to answer it. So feel free
What's
to hit me
your
up.
WhatsApp number again, Sridhar? I will
Yeah,
put it on the screen.
017 888 4759.
4759. So I will add it onto the screen now, and you can see you can WhatsApp Mr. Sridhar at 017 888 4759. Is that correct?
Correct.
Is that correct, Sridhar? It's all right.
Yes, 017 888 4759. That is correct.
Okay. So anyway, let's go on to the questions quickly, because let's move.
What's the
Yeah,
next
this
one?
one.
What legal principles guide
What
the calculation of?
legal principles guide calculation of aggravating damages? Are there
You know,
specific formulas?
Yeah, they used to say this about equity. It's the size of the chancellor's foot. Right now, different judges,
Mm,
different judges are running off in different directions. It's very unclear as to what is the appropriate amount. It literally feels like it's figures being plucked out of the sky. The thing that you can do to minimize it, as I said before, sympathy, empathy, very good note taking, and good explanations for things that go wrong. If there's a delay, why?
mm,
Everything comes
Yeah.
back to note taking. If it wasn't noted, it wasn't done. So these are the things that you can do to minimize it. Formulas and methodologies used to determine appropriate amounts. I'm afraid we don't have one.
Okay. What Dr. Aryan says, what can the legal and medical fraternity do to mitigate an unfounded award of aggravated damages? I think you covered some, but maybe you
Yeah.
just want to summarize for the audience.
Well, first one is, of course, get competent legal representation, and don't be afraid to appeal a decision that you think is unfair, because if you don't, then it becomes law.
Mm.
That's how bad law is made.
Yeah. And I think you mentioned don't add salt to injury.
Yes,
Yeah.
yes.
Yeah.
That's empathy and sympathy. Yes.
Yeah. Sometimes it's so frustrating, and it can be quite difficult to maintain that decorum.
Yes,
Mm,
yes. But it's very
how
expensive if you
can
don't.
how can doctors maintain a balance between evidence-based medicine and patient preference? Mm.
Could you explain the question to me, Dr. Allen? I'm not
Yeah,
quite
I
sure.
think okay, we've probably give advice on treatment, which is based on whatever evidence we have,
Yes.
clinical
Yeah.
evidence. At the same time, the patient may have his own viewpoints.
Okay. Understood.
At the
Yeah.
same time,
Actually,
they have their
yeah.
own ideas, maybe what they Googled, what they
Yeah.
have
Yeah. Yeah. I completely
heard
understand.
from their uncle and auntie. And then at the same time, the court wants us to maintain patient autonomy,
Yeah.
and then we
Actually,
cannot be
there's no
viewed as
conflict here.
paternalistic. Yeah.
Yeah. There's no conflict here. As your job is only to give the patient all the information. If having given all that information, the patient makes a silly or asinine decision to go off and see a witch doctor, it's too bad. But have it noted. So as long as you gave him all the correct options and he goes off and runs off and does something really stupid, you're still covered. So no conflict there.
Okay, I'm going to add on something to this. Okay, I've advised a particular course of treatment or surgery. Patient decides on something completely ridiculous. All right. But we see you now, Sridhar. Hello.
Yep.
Okay. Can the doctor say, look, I can't look after you now because you have chosen this ridiculous course of action, which will likely land you in trouble. And if you do so, I have to say you need to see somebody else.
Yep, absolutely.
Is that all
For
right?
instance, if it's absolutely. Let's say it's a macrosomic baby. You're an ONG, and you've told her, look, you can't have a vaginal delivery. You have to have a C-section. And she says, no, I don't care. I want to have a vaginal delivery. Then you can say, look, then I'm not going to treat you because you're going to end up getting sued, right? So she goes
Yeah.
against your decision. You can wash her to say, look, then I'm not going to treat you. You're perfectly entitled to do that.
Yeah, I think that this sort of same covers the same thing.
With increasing emphasis on patient autonomy, shared decision making, how do doctors balance their duty to provide? Well, I think, there you go. That's been answered, I
Yeah.
think.
Mm.
You're
So a
only
lot of questions.
obliged to give the information, right? What the patient does with it, it's not your problem.
In cases where multiple defendants are involved, how do courts determine whether to award aggravating damages individually or jointly?
Right. From the evidence, the court will have to decide. Like, for instance, there may be nurses who are negligent. There may be doctors who are negligent. There may be equipment that broke down, right? So you'll have the hospital liable for faulty OT equipment, and if the hospital was tardy in the way that it maintained the equipment or refused to give documents and stuff like that, then it's the hospital. Like, for instance, let's say there's an internal inquiry that shows that the hospital was negligent and the hospital refused to disclose it. Then that's no fault of an independent contractor or a consulting or visiting consultant. He had nothing to do with whether or not the document was released to the patient. So that in that sort of clear situation, the aggravating damages would be would be directed towards the hospital and not the consultant or visiting consultant or the doctor. On the other hand, if there was nothing wrong on behalf of the hospital and it was the doctor, lackadaisical in the way he treated the patient, then the hospital would not be liable for aggravating damages and the doctor would be. So it's really based on the evidence that comes up during trial.
Okay, quickly, what factors are considered when apportioning liability and damages amongst defendants?
Well, who's liable and to what extent? The variabilities are infinite, really. In evidence, you'll find out from the doctor's testimony, from the patient's testimony, and from the experts' reports. The experts also play a big role. They will point out who was at fault. Was it the nurse at fault? Was it the doctor at fault? Was it equipment at fault? So that would basically dictate the apportionment of liability and damages.
And are there any limitations on the amount of aggravating damages that can be awarded? The sky's the limit.
The sky's the limit. I mean, you've got Hari Krishnan, $1 million, and then you've got other cases, $500,000, and it's not even clear sometimes how that figures are arrived at. In every other sense, it's very clear. I mean, how much is a blind eye worth? $200,000. Everybody knows that, depending on the age of the patient. But when it comes to aggravating damages, it's really sky's the limit, and it really depends on the particular judge. How do courts ensure that the award damages are proportionate? Again, depends on the judge. That's why aggravated damages and punitive damages are very worrying. It's almost impossible to predict with any degree of certainty or uncertainty, for the matter, what it's going to be. It's just
difficult because
it's how reprehensible that behavior is held out to be. And sometimes it's very subjective. If you have a patient who is a very good actor who can break down and cry buckets in front of the judge, you could be in trouble.
And judges are also human, I think.
Yes.
I mean,
Yes.
how they can be influenced by all these various things. So it's very difficult for the doctors when things are so arbitrary and nothing.
Yes.
Uh, the goalposts are not defined.
Yeah.
If it's
Yeah.
moving all the time, it's difficult. Yeah. And can these be awarded if there's no direct financial loss to the plaintiff?
Absolutely. Absolutely. Direct financial loss is special damages. The cost of treatment already incurred, the cost of future treatment, um, cost of modifying your home to suit the patient who is no longer able to act as before, prostheses. These are all special damages which can be directly attributed to a financial loss. You can put a figure on it quite easily. But aggravated damages, no. It's aggravated damages is basically insult. How much are your feelings hurt? It's not a direct financial loss at all.
So let's say the plaintiff has no financial loss, so maybe everything costs were covered by insurance and all that.
You're still going
Can
to get
so
whacked.
you can
Yeah.
still get aggravated if the patient was hurt in some
Yes.
way,
Yes. Yes.
emotionally or something. Okay.
The closest analogy is
Mm.
defamation, really. You defame someone, yes, you have to show a financial loss. But even if you can't, the fact that you defame that person in itself, the hurt that you caused him, uh, that people may look at him with a lowered expectation of his dignity and stuff like that, is enough to give you damages. It's the same thing here. Okay,
I think
we're
we
back.
covered this next
Yeah, yeah,
question. Yeah, determine
yeah.
the appropriate compensation for non-economic harm, emotional distress, reputational damage. How does the court determine the appropriate
The
compensation?
answer to that is how long is a piece of string, really? Nobody knows.
Very difficult. Yeah, I think let's move quickly. In a case involving corporate entities or institutions, what constitutions come to play when determining the liability for aggravating damages?
I don't understand. How does medical negligence? How do you? How do you? I don't really
I
get the
think he's
question.
talking about if it's a corporate entity or institution. Um, Not very clear. Maybe.
Are you talking about a hospital being the corporate entity or institution? I can understand because obviously the patient can't be a
Mm,
corporate entity or an institution.
mm, mm,
Uh,
mm.
Same thing. A hospital can be held liable for aggravated damages if it unnecessarily withholds medical reports, internal inquiries, so on and so forth. So, yeah.
Okay, we better move. And Dr. Dude Lam, thank you for the excellent talk. In the current situation, there are nutritional medical practitioners aiming to provide a mobile service to clients. And is there any special license or regulations regarding this? And what should they do to safeguard against medical legal issues? So I
Right. I,
presume these
I'm
are
sorry, I won't be able
doctors.
to answer it.
Who,
Yeah, I won't be able to answer this question. This is a licensing issue.
yeah, I think not quite covered.
But dude,
Doctor S.
you can send me a WhatsApp. Maybe I can try and help you out later on. KPM,
Sure.
is that consents? But
Uh,
okay, we do medical. Absolutely, absolutely, yes. It would hold up in court.
hmm,
You know, uh,
okay.
a consent that is specifically tailored to that
Hmm.
specific patient, taking into consideration that patient's age and all other special consideration that patient displays, would go a great way to saving you in court.
Okay. All right. Um, Anyway, just to let you know, there are a lot of people who have appreciated Satish says great talk. Thank
Thanks,
you.
Dr. Satish.
Wilson Tan, thanks
Thanks,
you.
Wilson.
Muhammad Yusuf says very informative. Or Ariane
Is
has one more question. Is there a need for legislation for duty of candor like in Hong Kong and in the state of Victoria, Australia?
there a need for legislation? I think the duty of candor applies in Malaysian jurisprudence without the need for legislation. I don't know exactly what type of candor what kind of candor you can add. You have to be absolutely candid with your patients. If you're not, you're going to get sued for aggravated damages.
Isn't it not? I suppose it means that we have to be honest and transparent. Is that right? Candid,
Yeah, but
duty or
that
candor.
duty already exists.
Mm,
That's all packaged up in your the duty that every physician owes his patient. It's already packaged
mm,
within that duty. So is he saying it needs to be legislated? Does it need to be made clearer? Possibly, but
mm.
that's the job for Parliament. So I won't really be able to answer that.
Okay. Aryan qualifies openness in disclosing what had happened.
Oh, absolutely, absolutely. Because the other thing that you need to worry about is if if you're not only are you going to get sued in a civil court, you might have disciplinary proceedings taken up against you for infamous conduct at the MMC or MDC. So yes,
Mm.
that's that's exactly
Okay.
what went wrong in the Hari Krishnan case. Not enough disclosure, and that's what happened. That's what how I
Okay.
read the case to me.
Yeah. All right.
One last thing.
I'll just.
Sorry, one
Yes.
last thing.
Sorry.
There's a
Mm,
problem that arises with internal um, inquiries. When things go wrong, hospitals will have internal inquiries with the intention of making sure that this doesn't happen again. What are the shortcomings, etc. And during these internal inquiries, of course, everyone is very candid because you're not looking at being sued. You're looking at trying to find out exactly what went wrong so that you can put it right and it doesn't happen again. Now, unfortunately, these internal reports nowadays seem to be a subject matter that is needs to be disclosed in court. Now that means that where a doctor or a hospital is being very candid, this can then backfire against them. So I would suggest that if an incident arises where the hospital thinks that it may result in litigation, it would be a good idea to contact the lawyers, ask the lawyers whether an internal inquiry ought to be held with regard to litigation, and if they're acting on on the lawyer's instructions or advice, then it would be hopefully be privileged information that doesn't need to be disclosed. So that's something that needs to be looked at, because otherwise, these internal inquiries are going to be stunted. People are not going to be candid because they worry that later on it will come up in trial. So that's something that you need
we
to
have a
look at.
question in Slido, and the person asks, "What if the patient's family members distort or lie?"
Uh, well, that can then, if due to a distortion or a lie, you then manage the patient differently. Your treatment of the patient is skewed because you were relying on this distortion or lie. Then, uh, hopefully, you can use that to defend yourself and say, well, my whole plan of treatment went wrong because you gave me the wrong information. And that can get you off completely. There's a case, if you send me a WhatsApp, I will give you the name of the case. Or at the worst case scenario, it can help to be contributory negligence by the patient. So even though you're held liable for giving bad treatment or mismanaging the case, to some extent it was the patient's fault, then the judge can give you a discount, if you like, by looking at contributory negligence by the patient.
Okay, we move on quickly. Can case notes be distributed to members of MAC who are reviewing mobility and mortality without consent of patient?
Mm.
That would be the medical advisory board or the committee who are reviewing M&Ms.
My off the cuff advice would be yes, but I would qualify that by saying I'm not 100% sure. And I think perhaps you need to check with the MAC. But I would have thought
Mm,
for reviewing boards and mobility, I think that should be all right.
I think we often do this in hospital, even if it's not an M&M, it's just a case.
Yeah. As long as it's within the medical fraternity and it's for a specific purpose, and
Mm,
I think you're all right. But heaven's sakes, don't go
I
and
think
share
we
it
have to.
online for purposes of discussing it with other doctors, you can't share it online. That's for sure. In a highly litigious society, how to strike a balance between practicing defensive medicine to minimize patient outcomes? Oh dear God, that's the $6 million question, really.
Mm.
That's it's
You do everything. Yeah.
yeah
It becomes also a very expensive practice to do everything if it's defensive medicine.
yeah
Yeah.
yeah yeah. A
Yeah.
common
And
sense
then it's
approach.
no longer cost effective. Yeah.
Yes.
Mm.
If you take the decision not to do a certain test or a certain course of treatment that you don't think is necessary, note it down. Explain why you didn't go that way, right? You're promoting cost-effective care, and maybe you can refer to refer to literature that says it's not really required. Guidelines, standard operating procedures. Just explain why it is that you did what you did, or why you didn't do a certain thing, and that will go a long way to saving you.
Dr. Aryan, who asked this question about the MAC and disputing
Hmm.
notes to members, says the Court of Appeal found one PIC guilty for distributing notes.
Wow. Dr. Aryan, if you could send me the citation for that case, that would be great, and I'll be more than happy to come back to you on that one.
Okay. So we'll have to look at the facts. I think we'll have to stop here. I know Srila is very popular, getting a lot of questions. There will be no end. We'll probably end at midnight if we just carry on. And I think we don't want to take too much of your time. I just want to thank you again. It was a very entertaining talk. And I thank you all for sitting through it. So here comes the part where, okay, we reward your patience, and that's the QR code. Now, this one is the for the medical doctors who are using the MMA app. You can take your MMA app and hang on. Let me remove that banner. Yeah, okay. So that won't block the QR code. So you can take your MMA app and then scan, and then it will register the point. Let me check it by scanning it myself. You need to be using a separate device to watch uh, the presentation and show and get the QR code displayed, and then with your phone you can scan. Unfortunately, if you are watching with your phone, you can't scan with the same device. It's a limitation of the MMA app. So, but you have to maybe you take a screenshot and send it to a friend of yours nearby, or family member, and then you can scan it off his or her phone. Okay, now for the those who are what now, this code will be valid until maybe around about 10 o'clock tonight, and after that it may expire. If you encountered that the code has expired, what you can do is go to our website, docs.my, okay, and then you click on the medical legal um, link, and you will see this page, okay? So on uh, the medical legal link is on top. Then you scroll down below the video, you will see a link to the CPD points module for the doctors that will take you to our bulletin board. And then you answer three simple MCQs. And if you answer all three successfully, you'll get the point. You'll be registered in the MMA app for you without having to scan the QR code. So you can use this method even though the QR code is expired. For the dentists who are watching, this time we've got a solution for you. Please click on the link to register for CPD points for the dentists, okay? And this is courtesy of the Private Dental Association, and they will help you get your points, okay? So just go to our website for or docs.my, and then you can get your points there, even though the live stream is over. So once again, Mr. Sridhar, thank you very much. And I think I wish everybody good night and have a great rest of the week for you. So we'll be ending the stream right now. And thank you, everyone, for watching. Good night.
Thank you for having me. Thank you, everyone, for watching.
Yeah.
Bye.
Yeah. Bye.